Yes, people. So let us continue with whatever the questions we were doing. Yes. Yeah, I hope this is helping you guys. Yep. Okay. So let us continue with the chapter 5 and whatever are the other chapters. Let us try to have a consolidated good number of questions from every chapter. Okay, referring to the provision of Companies Act 2013, state whether the following amounts received by the company, does it constitute a deposit or not? First one, IQ Books Limited received share application money rupees 50 crore from investors on 8th December 2024. As the issue was undersubscribed, the company refunded the amount to the investors on 20th February 2025. So they're asking you whether this is considered as deposit or not. Now you guys know one scenario, no people. That is whenever you have received share application money, you need to make the allotment within 60 days. If you're not able to allot, then you need to refund it within 15 days. That's the whole process. So technically, how many days you get? You get 75 days from the date of receipt of share application money. Now, people, one tricky part here is how do we calculate the timeline? Yes. So if you apply General Clauses Act, what do we do when we are counting 60 days from the date of receipt of money? We technically have to exclude the day on which we receive the payment. But technically, what does the rule say? You need to allot within 60 days from the date of receipt of money. So from that day to 60 days, right? So remember here in the, what do you say, in the days calculated, how the institute has taken, they have people taken, if you look at the calculation, now how they have taken from 8th December to 20th Feb. Now they have taken 24 days in the month of December. Correct? 24 days in the month of December. That means what? If you look at it, if I out of 31 days, if at all I'm excluding how many days, if I'm excluding 8 days, how many days will I get? I will technically get around people 23 days. Agreed, huh? But technically you see how many days they got? 24. Because what they've done, people, when they're counting the money, you need to allot the share within 60 days from the day you have received the money. So what they have done, people, the day they have received the money, they have counted that day. Are you getting the point? So, sir, because of that, now what happens, sir? I will have to count this, what is that, in your December, instead of, in our calculation, instead of excluding 8 days, you will be excluding 7 days. That is how you are going to take the calculation. Are you getting the point? Yes. So, sir, now because of that, what happened? If I exclude 7 days, I get 24 days left because the 8th is included here. Hello, are you getting the point? So, sir, 24 days. In the next month, 31 days. And see here also, now this I'm taking a literal interpretation of the institute. When is the day of payment? They have repaid the money. Refund is done on 20th Feb. According to me, people, the day they have refunded that money, the day has started. So technically, you should have taken that. But people in the calculation, they have excluded the last day. So technically, they have taken 19 days in the month of Feb. They have excluded the day they have made the payment because according to the, see, this is the interpretation, people. There is nothing else here. Now, what is the interpretation here? The interpretation they have taken is the day they have made a repayment. Then you should not count it as a day of default. It is already done. Is what is the interpretation they are taking. But I believe the, if you look at the words, when they have given 60 plus 15 days, they have not mentioned clear days. They have not told us how to calculate it. So you generally should have applied General Clauses Act. This is the interpretation that the institute has taken. According to me, you should have taken 20 days in the month of Feb. But they have taken 19 days here. That's the problem here. Yeah? Because they have not said how to calculate this scenario. Are you getting the point? All of you? Okay. So applying that, people, they got 74 days. Even if you put our logic, sir, this becomes 20 days. It will still become 75 days, which is according to the law. So hence, I will not treat it as a deposit. Remember? Are you able to understand? Good. Next one. Suraj, Raj and Tejas are the promoters of Precious Jewelers Limited. They borrowed a sum of 200 crore from ABC Bank Limited for its working capital purpose. The bank imposed a stipulation that the promoters should contribute at least 20% of the amount borrowed. Hence, Suraj brought 10 crore, Raj brought 15 crore, and K, the father of Tejas, brought in 15 crore. Remember, people, what is not considered as a deposit? As per the definition, people, any money brought in by the promoters because as a stipulation by any financial institution, and as far as that loan exists, that money will not be treated as deposit. What will be not treated as deposit? Any money brought in by the promoters or their relatives. So the toughest part here was, people, whether the money brought in by the father, will this be considered as a deposit or not? Remember, it will not be considered as a deposit. Is this clear, all of you? Hello? Okay. Next one, sir. Pretty Cosmetics Limited issued non-convertible debentures of for 125 crore and listed it on a recognized stock exchange adhering to SEBI rules and regulation. The company created a charge on its assets in favor of debenture holders and duly registered the charge. Remember, people, if it is a non-convertible debenture, then it has to be mandatorily listed on a stock exchange. It should not constitute a charge. Sir, what if it's a non-convertible debenture but not listed? You will treat it as, people, a deposit. Sir, what if it's a non-convertible debenture which is listed on stock exchange and which constitutes a charge? It is treated as deposit. It should be free from charges. There should not be any security created. So in the given case, you will treat it as a deposit because the charge is created. Is this clear, all of you? Yes? Okay. Okay, next one, sir. PRT Limited is an eligible public company. The following details are available from its audited balance sheet. Paid up capital, free reserves, existing deposits from members, existing deposits from public. It's an eligible public company. They are only giving it to you in the information. What is an eligible public company? Net worth of 100 crore or turnover of 500 crore. Okay. The company now proposes to accept further deposits during the year 24-25. So there is already existing deposits. Now they want to raise more deposits. So now how much, what is that they're telling you? They want to raise 3 crore from its members and 2 crores from person other than members, that is from general public. You are required to examine with reference to the relevant provision of Companies Act whether the above proposal is valid. If not, calculate the maximum permissible deposits in each category. Now, in the given case, what has happened, people? What is the maximum deposits we can accept? Because you are an eligible public company, I can take 10% from members, 25% from public on my paid up capital, free reserves plus securities premium. So that will be how much? 28 plus 2, 30 crore. On 30 crore, how much is 10%? 3 crore. On 30 crore is how much is 25%? 3, 6, and that will be around 7.5. That is a thing. Yes, okay. Now, in this case, what has happened? 7.5 crore and 3 crore. Okay. And existing deposits from members, already how much we have? 2 crore. How much more we can borrow? We can borrow another 1 crore. Because 2 crore we have already borrowed. Another 1 crore we can borrow. So we can go up to maximum another 1 crore. Next one, existing deposits from public. We already have 5 crore. How much we can do it? We can do 7.5 crore. So how much more I can do? 2.5 crore I can raise it from public. So the company, whatever they are doing is valid. Is this clear, all of you? Yes, that's it. That is what is going to be my provision of law. Clear? Yes? Okay. Okay, next one. NOP Limited, since its incorporation in 2002, is engaged in the production of premium quality glass bottles. According to the financial results of the company as on 31st March 2023, the net worth of the company was 90 crore and turnover for the year was 510 crore. Public company having a turnover of 500 crore, so it is a eligible company. The company proposed to accept the deposits as on 1st Feb 2024, which would be due for repayment on 30th September 2028 from the public for expansion and redevelopment programs of the company. Furthermore, the company has accepted a loan of 1.5 crore from Mr. P. Kishore, and the loan was to be repaid after 24 months. Company in its books of accounts records the receipt as a loan under non-current liabilities. At the time of advancing loan, Kishore affirms in writing that such amount is not being given out of the funds acquired by him by borrowing or accepting loans or deposits from others, and complete details of such loan transaction is furnished in the board's report. Okay. On the basis of the above facts, answer the following. Whether company was eligible to accept deposits from public? What is the criteria? Were they eligible people? Answer is net worth is. See, net worth is less than 100 crore. But it is what? Any one condition to be satisfied. Yes, they are eligible. Acceptance of deposits and tenure for which the deposit can be accepted. So there are both people. One is you are eligible, you are an eligible company. Second one is people, what is the tenure? The minimum tenure people is 6 months, maximum can go up to his people 36 months. Here, when did you accept it? You have accepted it in the month of when? 1st Feb 2024. So if I take that way only 24, 25, 25, 26, 26, 27, 27, 28, you're going beyond 36 months, which is a violation, non-compliance with the rules, because the maximum allowed tenure cannot be more than 36 months. Hence, people, whether the tenure decided by the company was in accordance with the provision, the answer is no. Next one, with reference to the loan advanced by Mr. P. Kishore to the company, state whether the same is to be classified as a deposit or not. It is not a deposit, people. Any money received from a director with a what is that declaration that it is his own funds and it is not borrowed funds, we will not treat it as a deposit. Hence, that is not a deposit. Shall not be treated as a deposit. Clear? I hope this was good and you were able to answer. The next one, sir, Element Limited from charge created a charge on one of its plant and machinery in favor of financial institutions. The company secretary was on leave when the charge was created. To avoid delay, an accounts officer of the company entered the particulars of charge in the register of charges without any authorization of the board. Later, a dispute arose between two creditors regarding priority of charges. One creditor challenged the validity of the register, claiming that the entries were unauthorized and not duly authenticated as per the law. Based on the company's rules, examine whether the entry made in the register of charges by the accounts officer is legally valid and what consequences may follow in case of non-authentication. Now remember, people, what has happened? A company has borrowed loan and they have created a charge. They have created it since they have registered the charge. Now, whatever the charge is registered, the company has to maintain it in the register of charges. You need to make an entry as quickly as possible. Now, who needs to make an entry? The entry is always made by the person authorized by the board. It can be director, it can be a CS or any other person authorized by the board. That is what is given. Yes. It must be authenticated by a director, CS or any other person specifically authorized by the board. In the given question, what I have done, the charge is created. Okay. And the details of the charge were written in CHG 7 itself. But by who? Not by director, not by CS. It was by an accountant. Okay, the question is, was he authorized to do that entry? Answer is no. He was not authorized to do that entry. Now what will happen? Now they're asking you, one of the creditor is coming and saying, because that particular charge was not properly registered, it was again subsequently registered with another company. They have borrowed a second loan on the same property. Now what they are trying to ask you is, now there is two creditor asking for the same property. In this case, they are asking you, now because there was no proper entry made, will this charge be considered as valid? Yeah. So the creditor is telling it is valid, but the second creditor on the same property they have borrowed loan again. No, he is telling no. This particular thing is invalid because they have not made a proper entry. Now, what is the answer? People, your institute has given you two answers. But now I'll tell you what is the right answer. The right answer is, people, remember, for a charge when it is duly created, when it is duly registered with the ROC, making an entry in CHG 7 is an internal matter, people, which is doctrine of indoor management. Outsiders are not aware of what is happening within the four walls. And I am not even concerned about it. I'm only, my duty is to make sure whether the charge is registered with ROC or not. If that is done, people, my obligation is done. Whether in your company's internal books you guys have made right entry or not is your headache, not my headache. So your institute has given you both answers. One, because our entries were not rightly made and hence the charge is invalid. And the second alternative answer is, the second answer I'm telling you, as it is an internal matter, the outsider is not affected as long as the charge is rightly registered with the ROC. In the given case, the registration happened properly, but the problem was within the company, doctrine of indoor management. They have not used the word, but you can use the word doctrine of indoor management. Internal irregularities does not affect the outsiders. Yeah, the law tried to protect the outsiders from the company. So in the given case, the charge is valid. According to me, that's the only right answer. But institute has given you both the answers. According to me, the second interpretation is wrong. Internal irregularity will never, nullify the external charge created. Is this clear? Okay. Consequence, people, of course, penalty is there. Remember the penalty and go. Next one, Vital Pharmacy Limited is engaged in the manufacturing of medicines to cure skin diseases. It has established the unit in Germany. It registered few patents in Germany and raised funds by creating a charge on its stock in Germany. My question to you, what type of charge is this called? And on the patent rights, the company registered the charge created on its stock but did not register the charge created on the patents. The company received a notice from ROC for non-filing of particulars of charge created by the company on the property or assets situated outside India. The company wants to defend the notice on the ground that it shall not be the duty of the company to register a particulars of charge created on patents obtained outside India, and also as they are intangible in nature. What is the answer, people? Section 77. It is your duty to register charge. You need to file CHG1 within 30 days of the charge getting created, whether it is, remember, movable or immovable, or tangible or intangible, whether in or outside India. Remember, any case, you have to register the charge. So that is the answer for it. Clear? So my provision will be that it is my duty to register the charge. I need to write all these three things. In the given case, the Vital Pharmacy's duty is to register the charge even though it is an intangible asset. Under the law, it is a mandate for you to register a charge whether it is in India or outside India. That's my conclusion. Hello. Okay. DNC Hydro Limited obtained a loan of 3,000 crore from SPM Bank in 2021 to finance its project. To secure the loan, the company created a charge on its assets, including land plant. The charge was registered with ROC in form CHG1. In September 2024, Hydro Limited fully repaid the loan and SPM Bank issued no due certificate to the company. However, due to internal compliance oversight, DNC Hydro Limited failed to file CHG4. What is CHG4? Satisfaction of charge within 30 days prescribed limit under Section 82 of Companies Act. In Jan 2025, RTS Bank approved a loan of 1000 crore to this company for acquiring new plant and machinery. During the due diligence, the bank discovered that the old charge was still active in the ROC records, thereby creating problem for disbursement of the new loan. As a financial advisor of the company, advise what are the legal and procedural steps in DNC Hydro Limited should follow to remove the old charge from ROC records. What should they do, people? First thing, they should have done it within 30 days. Correct? But they have clearly said it has failed to file form CHG4 within 30 days. So what should the company do? The company should technically file form CHG4. If you had filed it within 30 days, it would have been normal fees. Now you should file it within 300 days with the additional fees. Remember, people, correct? When you file CHG4 with registrar, the bank, the borrower has to file, correct? What will the ROC do? ROC will generally check with the creditor. Hey, he is telling that he has repaid your loan. Has he actually repaid? You will have 14 days to reply. If you do not reply, it will be considered as a deemed approval. Now, in the given case, people, will this step come or not? Remember, people, you have given a no due certificate. If I attach that along with CHG4, this 14 days process can be skipped. In your exam, they have given this. According to me, not required. Because that process is specifically there in our book. It's there in the act. If you can give the consent of the creditor along with CHG4, again a cross verification with the creditor is not required. This can be exempted. Yeah. So they have given this, or they have said you can file alternative also. I'm saying this is not right. You need not have to give any notice. You can directly register a charge. The ROC will reply with memorandum of satisfaction of charge in CHG 5. Clear? Simple? Done. See, alternate. Bank has already issued a no due certificate. This is the right conclusion. This is not right. Clear? See, the institute is helping you so much. Okay, Saras Ventures Limited, a public company incorporated under Companies Act, has a board comprising 7 directors. Okay. A group of shareholders holding 1.2% of total voting power has expressed dissatisfaction with one of the directors, 1.2 percentage. Mr. Ankur Chabra and has proposed his removal under Section 169 of Companies Act. The company's annual general meeting is scheduled for 25th August 2025. On 1st August 2025, the company received a special notice under Section 115, proposing an ordinary resolution for removal of Ankur Chabra at the upcoming AGM. However, the company subsequently failed to notify its members of the special notice. With reference to the applicable provision of Companies Act, examine the validity of the special notice. What are the consequences of failure to notify the members about the special resolution? First of all, people, was the special notice properly given by the shareholders? Special notice has to be given by the people holding at least 1% of the total voting power or 5 lakh rupees paid up. Correct? Now here it has been given by 1.2%. So valid number of people have made a request. Now the request has to be given when? It has to be given at least 14 days before the meeting and not more than 3 months prior to the date of the meeting. When is the date of the meeting? Date of the meeting is August 25th. When is the notice given? 1st August. It is clear days. Of course, it is more than 20 days only in between. So this is also properly given. Now, what should the company do? Company, once you receive a special notice, I hope you guys understood Section 115, because they have filed an application to what do you say, discontinued a director, removal of a director. So in this case, now what will happen? The whatever is a notice given by this 1% of the people, you need to intimate it to the rest of the 88.8% of the people that we have received such notice. Now people see, this is a tricky part. In section 115, the section is silent. What if the company has received a special notice, but they did not inform further to the other shareholders? The question is, I mean, the law is silent. It does not speak anything. So people, it is an assumption, again an interpretation. You cannot introduce any matter in the meeting without a proper notice. That is a rule of the law. If you have not intimated to the shareholders, immediately in the meeting, you are not supposed to take any decision. So if a company does not intimate the shareholders about the notice people, then remember the company cannot take up that matter in the meeting. So the failure, what are the consequences of failure to notify the members? Consequences, people, the company cannot consider that matter, cannot take up the matter in that particular meeting. Hello, that's my consequence. Is this clear, all of you? But the again institute has given you two interpretations. One is this. Second one is, if at all you cannot, it is not possible for you to give an individual notice, you can give it in a newspaper. People, they have said what are the consequences of failure to notify the members. They have not said whether personally or by newspaper. So that newspaper answer, according to me, should not come up at all. But they have given you as an alternate answer. According to me, it's wrong. The only answer that can exist is, people, the only answer is it will be treated as invalid. Hello? And it does not have any penalty and all for the section. Clear? Okay. See, different interpretations. See. Correct, no? Okay. Next one. Monica Solutions Private Limited is registered as a OPC under the Companies Act 2013. Gautam Kumar is a sole member and director of the company. With the financial year ending on 31st March 2025, the company is preparing to comply with its annual filing and disclosure requirements. Gautam Kumar is uncertain whether his company is required to hold an AGM. Because you are an OPC, you are exempted from holding AGM. Or there are any other alternative procedures that his company can follow. As a financial advisor, please advise Gautam on this matter. Of course, people, there will be nothing. Within 180 days of closure of financial year, you can directly just file your financial statements with the registrar. And in a OPC, they are exempted from conducting a AGM. You can directly open the minutes book, directly enter whatever you want to enter. That itself will be considered as a valid resolution. Yes, what is the difference between the word motion and resolution? Motion is nothing but, people, whatever is the proposal submitted in the meeting to take the shareholders' decision, that is called as motion. What do you mean by resolution? Resolution is that proposal, once agreed by the shareholders, it becomes a resolution. Decision by the company's shareholders, it becomes a resolution. That's the difference between motion and resolution. Okay, next question. Each question, how will you guys manage in exam? Oh? Okay. Autumn and Spring Limited is a public company engaged in business of manufacturing traditional designer garments for men and women for various festives and occasions. The company was incorporated in the year 2023 and has a paid-up capital base of 200.56 crore and revaluation reserve of 75. Members holding share capital worth 36.52 crore have jointly applied for calling a EGM. Requisition EGM, section 100, for transacting above urgent matters of special business. In this connection, a requisition by the above members were validly presented to the board of directors on 1st July 2024. The directors did not pay heed to the above request till 24th July 2024. Hence, the requisionists decide to go ahead with calling the meeting by themselves. The requisionists provided a notice signed by only one of them being duly authorized by others of the said meeting through an email, but did not attach an explanatory statement as required under the Act towards the special business to be transacted. Sohan Lal, one of the shareholders who became member of the company on 10th July 2024, raised issue regarding the legality of the members as its notice was not mailed to him. Referring to the relevant rules and provisions of Companies Act 2013, decide the following. Okay. Whether the above requisition by the members was adequate towards calling an EGM. When will the EGM be considered valid, people? At least 10% of the people voting having the total voting power, they should do a 1/10. Now what is my total paid up capital? 200.56. In that, how much is 10 percentage? That will be around 20 point something. How many people actually have raised it? The total is 36.52. Definitely it is more than 10%. So the request is validly made. Okay, next one. By requisionists themselves, whether signing on the notice by only one of the requisionists, is it valid? Remember, people, for a requisition to be valid, it must be signed by all the shareholders. That is the first thing. Sir, if all the shareholders is not able to sign, you can authorize one amongst yourself, one person. And if that person signs it, that is also sufficient. And this authorization can be even given in an email also. So yes, this one person signing it is still considered to be valid. Okay, next one. Further, whether the contention of Sohan Lal not receiving the notice is correct. No, non-attachment of explanatory statement. Remember, people, whenever the requisionists are calling for a meeting, explanatory statement, even if it is not attached, it is valid because they are conducting the meeting. They do not know that particular aspect. Further, whether the contention of Sohan Lal not receiving the notice, is it correct? People, see here, one thing that I would like to tell you. People, first thing, what is EGM thing? Within 21 days, the company has to take steps in calling a meeting. And within 45 days from the date of the request, the company has to conduct a meeting. If they do not do so, within 3 months of the date of request, the company can, the requisionists can conduct the meeting on themselves. Correct? Here the request was made on 1st July. And still, as on the date of 24th July, they have not yet conducted the meeting. Now see what they're telling you here with regards to the last fellow, Sohan Lal. Also, since Sohan Lal became member of the company on 10th July 2024 and the requisition was presented to the board on 1st July 2024, the contention of Sohan Lal raising the issue of legality of the meeting on the ground that the notice was not mailed to him is not correct. Now, according to me, people, I have a different opinion here. What is my opinion? Remember, you have given a request to call for a EGM on 1st July. Now, as on 24th July, they have not yet conducted a meeting. Now, you can only conduct a meeting on your own, correct? Now, what will be the procedure? The directors will hand over the register of members to the shareholders. Now, when did this fellow become a member? He became a member on 10th of July. And remember, whenever you become a member, within 7 days, people, your entry will be made in the register of members. So, according to that, by 24th of July, Mr. Sohan Lal's name will be written in the register of members. So, remember, you will not call the members who has given the request. You will call everyone for the meeting. So, according to those grounds, according to me, whatever the answer given again is wrong. Because what will be the interpretation? The interpretation should be if Sohan Lal, if they have, what do you say, accidental omission, then people, it will not invalidate the meeting. If at all it is an incidental omission, it will invalidate the meeting. If Sohan Lal's name was there on 24th July on the register of members, Sohan Lal is deemed to get a notice of the meeting. You cannot exclude him. Hello? Because it all depends upon, you would have seen, no, closure of register of members to decide on the, right on who will get the notice. So on that day, if my name is there, then I will be eligible. I will be entitled. Clear? So that's one thing that they should have written. What is the record date? That is called as record date. On that day, whosoever name is there, they will be entitled for the notice. So according to me, this interpretation might be a little more right. It's not right. Yes. Fabulous Fabricators and Mechanics Limited is a listed public company incorporated in the year 2023 with the object to manufacture and engage in the construction of iron ore based infrastructure for various industries on contractual basis. Okay, the company is having a paid up capital of 200.30 crore divided in 865 members holding right to vote in the meeting. The AGM of the company was to be held on 12/12 at the registered office of the company. The board of directors decided to provide facility of e-voting to its members in addition to other modes. Despite of the disagreement shown by Ms. Riddhi, one of the directors, who was of the view that in case of above company, it was not mandatory to provide the e-voting facility. On the day of the meeting, Mr. Mohan, one of the members who had opted for e-voting, could not exercise his option, hence was physically present at the meeting to vote. The chairman of the meeting did not allow him to physically cast his vote on the pretext that he had opted for e-voting and now he cannot change his option and thus had to vote through e-voting despite of being present. Further, a matter regarding appointment of Mr. Keshav as a small shareholder director was also to be discussed in the meeting, to which legal team suggested that the same can only be undertaken by voting through postal ballot and not otherwise. Referring to the provision of Companies Act, elaborate. So there are three questions. The first one, whether the contention of Riddhi was correct with the provision of e-voting. Riddhi is telling what? We are a listed company who is having only 865 members. Now, should we give e-voting or not? If you read e-voting, people, what does e-voting provision say? Yeah, section 110 says every listed company and a company having a what 1000, basically minimum not less than 1000 members, they have to compulsorily provide e-voting facility if you're a listed company and having members not less than 1000. Now the question is, sir, they are listed, but how many members they have? They have 865, they don't have 1000. What are the conditions here? Listed and 1000. Hello, are you getting this point? Now, people, remember, I would have said this to you in the class also. You have to read these conditions separately. They are not together. If you guys remember your interpretation of statutes, there will be one interpretation called as exceptional construction. And can be read as or can be read as and. Here, this, if you read it as and, purpose is not served. If you are listed, by default, e-voting is mandatory for you. So here the word and should be read as not conjunctive, disjunctive word. You have to read it as or. Understood? Are you getting the point? So the contention of Riddhi is wrong. You have to mandatorily give a e-voting facility if at all you are a listed company. Simple. Okay. Can the chairman stop Mohan to physically vote? No, people. Remember, a person who has not yet voted in the e-voting can come and attend the physical meeting and also vote. But if you have already voted, you can attend the meeting, but you cannot vote. In the given case, he has not voted. So he can come and he can also vote as well. So chairman's contention is wrong. Is the suggestion of legal team regarding appointment of Keshav valid? Remember, people, you need to know the list of things that can be considered by postal ballot. In that, yes, we would have written also small shareholder director. So if you want to appoint a small shareholder director, it has to be, what do you say? That decision has to be taken by postal ballot only. That's the answer. Hello. Is this clear? Yes. Okay. Our next one. Arch Support Limited is a public limited company incorporated in 2018, having its registered office in Nashik. It is access. It has the following breakup of equity in preference. It has 1,20,000 equity shares of 100 each, 1,50,000 10 lakh preference shares of 10 each. Miss Martha, one of the elite members from Jaipur, holds in her name equity shares worth 6,50,000 of the company as on the date, and also has beneficial interest in the equity shares worth 3 lakh. Concerned about the declaration to be made by her as mandated by company in SBO provisions. She consulted a CA, Ms. Marina, her friend on the above issue, who advised that since she has SBO ownership directly and indirectly in the company, she is required to file the declaration as mandated by the above rules. Referring to the above provisions of the Companies Act, decide on SBO rules. What? Whether the advice given by Ms. Marina, is it right? SBO rules are applicable in every case and mention the instances where the SBO provisions are not applicable. Remember people, SBO, when is it applicable people? For any person who is holding at least 10% of the total voting power, 10% of the total paid up share capital, who is eligible for 10% of the total dividend declared, and who has significant influence or control over the company. They are called as SBO. In the given case, remember, this 10 percentage can be held, it can be directly or it can even be indirectly. In the given case, what has happened? She directly holds 6,50,000 shares in a company and she has a beneficial ownership. That means what? She is not a registered owner, she is a beneficial owner of 3 lakh. So I need to add a 6.5 lakh plus 3 lakh, which will be people 9.5 lakh. Now, what is the total paid up capital of the company people? That is 1 lakh. So she is having equity shares worth 6 lakh 50 and equity shares worth 3 lakh. Correct? Huh? So now you take from 12 lakh, 1,20,000 equity shares into 100 each. Yes, sir, into 100 each. That means how many shares does she have? She has 3,000 plus 6,500, 9,500. In 1,20,000, how much is 10 percentage? 12,000. How much do I have? 9,500. Of course, people, I'm not having 10 percentage. So she is not considered as what? Holding significant influence, and hence SBO provisions are not applicable to her. Hello? Okay. And of course, direct question, which are the cases when SBO does not apply? IEPF, your central government, state government, intermediary company or holding company which has already complied. For all of them people, of course, this will read InvIT, RBI, any intermediaries or any investment vehicles which is authorized under RBI, IRDA, as a case may be. That's a direct question, correct? Yes, okay.